to do first. So that you're able to step in and act as quickly as possible and make sure that you are able to actually handle the estate effectively, or if you need to seek assistance, when to do that ideally, rather than trying to go it alone if you're feeling uncomfortable doing so. Probate works a lot differently than I think a lot of people maybe anticipate it would, how it will work. Maybe they're unaware of which assets will actually be subject to probate versus which ones won't be. And in theory, which assets should be subject to the will then too, according to probate. So we'll go through all of those things and sort of touch on all of them. In particular, sort of being aware of the assets, I think, is incredibly important. All right, so welcome everybody. I'm Justin Randall, one of the attorneys at Hooper Law Office. As I mentioned a moment ago, our topic today is on what personal representatives need to know about going through probate, what they need to be aware of. This again is interactive, so if you're watching me right now, you should be able to submit questions, and I can see them come up on the Q&A function. So please, if you have any questions, submit them, and I'll be able to answer them as I go through things. A couple of housekeeping items. After this webinar, you'll receive a couple of things from us. One is our chart of what goes through probate and what doesn't, which is just a helpful little summary for especially if you're a personal representative. And then you'll also receive some forms at the end of this via email where if anything we talk about today raises any sort of concern for you, or you need to be able to talk to somebody about dealing with someone's probate estate, or for example just getting your own estate set up properly, that'll give you a place to let us know that you'd like us to reach out to set aside time to meet. We do offer complimentary initial consultations, so that is not, there's no charge to come in and meet with us initially. We schedule them for 2 hours, and usually by the end of those 2 hours, we should be able to give you a pretty good idea of what we need to do. Now, probate can function a little differently, just because then we're more looking at what we need to do based off of either existing documents or the lack thereof. But in terms of setting up your estate plan in particular, we can give you a pretty good recommendation by the end of that first meeting. All right, so when we're talking about probate, one of the first questions that I get a lot is, what exactly is probate? A lot of people have heard of the term, or heard that you should avoid it, or, have heard things about it in general, but don't really know what probate is as a process. Really what probate is the court process in which somebody's estate is divided up in accordance with either their will or the state statutory provisions if they lack a will. Their intestate provisions is what they're called. So even if somebody does not have a will, statutorily, there are ways that according to their, whether they're single or married, or if they have, kids or, blended families, things like that, how their estate should be divided up, even if they don't have a will. But wills are the instructions then to the probate court of how you want your assets divided, right? How, who you want in charge as a nomination for the personal representative, and how you want those assets to be split after all expenses are paid. So wills do go through probate. They don't help people avoid probate at all. That is the purpose of a will. A will is a list of instructions, like I said, to probate of how you want your estate administered. So having a will does not help you avoid probate. You need to have other tools in place if you're trying to avoid probate. But if you're not trying to avoid probate and you have provisions in your will, then there are certain things you need to, set up properly with accounts to make sure that they'll actually be subject to the will and go through probate, or at least follow the provisions of the will. With nominating a personal representative, that's also done in a will. So not nominating a personal representative, it's a provision that somebody would put in their will saying, I want so-and-so to be my personal representative for my estate so that they can, pay the bills and be in charge of these sorts of things. Now, a personal representative, if that term doesn't sound familiar to you, all that is what Wisconsin refers to, executors as a personal representative. So an executor and a personal representative are exactly the same thing. It's just what Wisconsin and a lot of states have started referring to that role as, just to make it a little more uniform across the board. So a personal representative is an executor, but they are nominated in the will. That nomination is truly a nomination. So if you know that you are nominated as a personal representative, there are things that you need to be aware of in order to begin acting in that role. It's not an automatic sort of appointment at that point. So what I mean by that is if I was named as somebody's personal representative in their will, I can't just take that will right after they pass away down to the bank and say, see, I'm named as a personal representative. So give me access to the accounts so I can start paying bills. In order to be actually appointed as a personal representative, you first need to submit that will to probate. You have to probate the will, and then the court will look at, okay, who's actually nominated here, and they'll give notice out to interested parties. Basically, that just means the beneficiaries or people who may object to that appointment, right? As long as nobody objects to that appointment of a personal representative, that process is usually relatively quick, a couple of weeks to maybe a month, assuming things are going smoothly. In the meantime, before that person is actually approved in that role or appointed as that personal representative by the court, they don't have access to the accounts. So they can't go down to the bank and say, I'm the personal representative until they have the right paperwork from the court. So those accounts are frozen, bills can't be paid in the meantime. And that's not as scary as that sounds, honestly. Creditors know, companies know that if somebody's passed away and their estate is going through probate, it's going to take a little while for them to get paid because those accounts are frozen temporarily after someone's passed away. So don't freak out just because you don't have immediate access to it. I mean, there's proper filing requirements. There's time restrictions on giving notice to creditors, things like that you have to abide by, and that the creditors have to come forward during that period of time as well. So, there's a process to this. It's not scary that you don't have immediate access, but just know that you won't have immediate access so that you don't, waste your time going down to the bank before you've actually submitted the will to probate. As a personal representative or upon receipt of the will, you should try to file the will with probate as soon as you can to get that process started. The sooner you get it in, the quicker you'll be approved, in that role as well. If people do object to that appointment, if somebody said, well, that person who was nominated as personal representative, I'm worried they're committing fraud, or I'm worried that they're just in it for themselves, they're stealing money, or whatever it is. If somebody objects to that appointment, the court will have to, have potential hearings on this to make sure that, okay, is this person really doing this? Are these valid concerns? Should somebody else be appointed in their place, right? So when I say it is a nomination, I mean truly that it is a nomination. The court wants to make sure these people are actually fit to act first. But again, as long as people sign off relatively quickly, it's not usually that complex of an issue. So that can just mean, though, that it's important to be comfortable with who you're approving or nominating as your personal representative. Make sure that if there are any sort of disputes in the family, or you think that might be an issue, that you're aware of it in advance, so that you can potentially prepare for that to take a little longer than usual. Now, somebody making a claim that somebody is committing fraud without any actual evidence that that's happening, or any sort of reason to believe that, of course, that's going to, they're very unlikely to win on that, but just be aware that it could take longer than usual if you're anticipating that. So once that approval has occurred, though, once the court actually says, okay, yes, this person can begin acting, that's when the personal representative will get what's called a domiciliary letter. So think of that sort of like the documented proof that they've been approved. They can take that document down to the bank and say, I've been now approved as the personal representative, so I can begin acting, and I can, set up an estate account. I can start paying bills. I can be responsible for all these things. That's what grants that proof. Without that document, banks are going to say, come back with the proper documentation. So wills, because they're only, subject to the probate process, they're not controlling assets outside of probate. We really want to make sure that they're submitted as quickly as possible so that that process has begun and access to accounts can begin. So once that approval has occurred, though, once somebody is actually approved as that personal representative, the personal representative really needs to be aware about certain, rules around what's going through probate and what's not going through probate and what they themselves actually have access to. So because wills only direct probate assets, that also means that if assets are not going through the probate process, if they are, for example, left directly to a beneficiary, the personal representative may not have access to those accounts at all if they themselves are not a beneficiary. So when you are setting up your estate plan, if you have a will, or if that is your intent, is to use a will as your estate plan document, make sure that you have funds in the probate estate, being left to the probate estate so that that person actually has access to those funds. This does a couple of things. One, if there are multiple beneficiaries, for example, you want to make sure that the personal representative actually has access to funds to pay expenses before certain assets are divided up, so that they guarantee that one person did not pay their fair share of expenses and never actually paid their 1/4 of their expenses, right? You want to make sure that those expenses are taken care of first before people actually receive funds from the estate. But it also makes sure too, on sort of the reverse side of that rather than naming that personal representative as a direct beneficiary so that they can pay expenses, it makes sure that they are required to pay expenses out of that amount rather than themselves just inheriting the money. But also makes sure that if that personal representative for some reason has any sort of personal liabilities going on, things like a bankruptcy, a lawsuit, long-term care concerns, whatever it might be, that the money they receive to pay expenses is not subject to those liabilities. If they are named as a joint owner on an account or the beneficiary on an account, and that's what you intend to use them to use to pay expenses, it could be subject to those things. So it's very important to know that if you have somebody as a personal representative, you'd rather give them access to funds through the probate estate than as an individual. Especially where multiple beneficiaries are concerned and there are possibilities of those sort of liabilities. But when we're talking about what goes through probate and what does not, I've mentioned beneficiary designations a couple of times. Things like payable on death, transfer on death, those sorts of designations that you often see on financial accounts or life insurance or IRAs or 401ks. Those do not go through probate when those designations are on there. They go directly to the beneficiaries listed after someone's passed away. So after the company has received a death certificate, they'll say, all right, we're going to begin the process of paying out to those beneficiaries. So those avoid probate because they transfer directly to the individuals. And the problem with beneficiary designations, especially when you're using a will as your primary estate planning document, is that it can be very disjointed between what your estate plan says you want versus what actually ends up happening. If you have a will but everything is beneficiary designated, that will does nothing for you. It does not pass any assets. It does not, make sure that the split actually occurs the way you want it to. The account designations will actually override those provisions in the will for those accounts. So it can be very, very confusing to a personal representative when, well, I'm nominated in the will. Why don't I have access to all of these things? Why don't I have the ability to pay expenses? Well, because all of the accounts were left directly to the beneficiaries and you don't. But as I mentioned, you also don't just want to name the personal representative as a direct beneficiary or as a joint owner on an account, especially in circumstances where there are more than one, ultimate beneficiary, or if the beneficiary is different than that personal representative. It's because if you name that personal representative as a beneficiary on an account, you've also then left them the money. They're under no obligation to follow the will because they are the beneficiary. Or if it's a joint owner, they're just the owner of those accounts now. So it's incredibly important if you actually want to guarantee that your estate plan functions the way you thought it would, have the provisions in the will actually control, make sure that you have those assets go through probate. Now, there are some assets that you don't want to go through probate through, being left to somebody's estate. But, those are really just like qualified retirement accounts for the most part. And that's because of the length of payout that they would have potentially if it was left to someone's probate estate. So you could potentially be stuck with with 5 years potentially as a max payout for that. So it's just important to be aware of how that sort of account would work after you passed away. But really, cash accounts, real estate, life insurance potentially, depending on the level of expense you think will be in the actual probate estate, those sorts of things are really important to actually leave to your estate if you're using a will, so that they are subject to probate. How you leave things to your probate estate, by the way, there's a number of different ways to do this. One would be to actually name your estate as the beneficiary on an account. The other would be to not have a beneficiary on it at all. It's just owned by you. And then when you pass away, with the lack of a beneficiary on it would automatically send it to probate. This is why real estate is often one of the main assets in probate, is because people just own it and then they pass away. There are ways to avoid probate with real estate as well, but most of the time what we see is at least the home is going through probate if somebody has a will as their estate plan. So as a personal representative, it's really important then for you to compile all of the financial information as quickly as you can, or if you are setting up your own estate plan, make sure that you have that information in a easy to access place for the personal representative, so that they can look at what they need to do right away. Make sure that if they don't have to deal with an account because it's already been designated out, that they know that, so they're not relying on that source of funds, but also knowing what they do have to be accountable for as well. So in that chart we'll send out to you, the through probate versus outside probate, is kind of a good breakdown on what would go through probate and what wouldn't, based off of how that asset is titled or how it is beneficiary designated. So I won't go too into detail on that beyond that. After they're aware of what they actually need to deal with, I mentioned that creditors kind of know they have to wait. And what they have to wait for is they have to receive notice from the estate that somebody's passed away, and if you have any debts that you're owed, make a claim against the estate. Now, the personal representative, if they know about creditors directly, so like if they knew about the mortgage on the home and they knew which bank that was holding that mortgage, right, they have to give direct notice to those creditors. They can't just give general public notice for that purpose. So you have to notify any known creditors directly, but you also have to give public notice too, sort of as a wide ranging, hey, so-and-so passed away. If there are any debts outstanding, and if we didn't give you direct notice because we didn't know about you, you have this period of time to come forward and file a claim against the estate. That period is roughly 90 days set by the court. They'll set the end date on that. If creditors do not come forward by the end of that period of time, after those 90 days, their claim may be null and void. They may not be able to submit that claim at that point. To give you an example of that, we once had a client who, they had a hospital bill outstanding somewhere after they passed away, like final healthcare was given to them. But the hospital didn't submit the claim they tried to submit the claim, well after that 90 days. They claimed it had gotten buried somewhere on somebody's desk. Well, that's not the estate's problem. That's not the personal representative's problem. That's the creditor's problem for not filing on time. So what that meant is they had to give up their claim. So that can be actually very beneficial to give that public notice. And if somebody doesn't come forward, within the allotted time, it actually increases the value of the estate. So as a personal representative, what you need to be aware of with that is you don't necessarily want to just start paying bills right away before that notice is given and before that time period is up, because you may not have to pay that bill otherwise if somebody has not filed their claim properly and within the allotted time. And as a personal representative, your duty to the estate is actually to maximize value. So you maximize value if a creditor doesn't submit their claim on time, and you don't then have to pay it, right? You're maximizing that value for the beneficiaries. So just be aware that, it's okay to wait to pay bills, especially when they're unknown. If they're trying to send threatening letters, things like that, that's not something they should be doing. They should wait. And you have no real risk of waiting to pay until those notices have gone out. So just be aware of that. Nobody can force you to personally be responsible for it as long as you're following all the sorts of notice requirements and you're paying those bills after the claims have come in. So payment of expenses, though, that's why it's also so important to make sure that there is a source of funds for that personal representative to use, because if they're trying to properly, respond to creditor claims by paying them off, if they don't have access to funds, that can be incredibly difficult. One of the most common issues, though, when there's not additional cash funds in somebody's probate estate, is the home or some sort of real estate going through probate where, well, there's ongoing utility bills maybe, or there's property tax bills they may have to pay for the year, or what have you. Well, if they don't have funds in the estate, how are they paying those expenses? So just be very, very aware that you want some things to go through probate if you're using a will. Now, things that are going outside of probate, that personal representative is not going to have any sort of access to unless they themselves are also a beneficiary. But you don't want to force them to use their share only to pay expenses. That may be not what your intended result is. Like I said, this is particularly a problem with multiple beneficiaries, or where they're each supposed to get equal shares and one person then has to use their expenses or their share to pay expenses. They can be reimbursed if there's money left over in the estate, but what happens if the creditor or the debt actually ate up all the value? Then there may not be anything left for them to be reimbursed. So it can be a pretty big concern if you're trying to make sure that things are follow the proper path there. Personal representatives should be aware that probate is not going to be an immediate process. It's not going to be over in a month. It's not going to be over in 2 months. As I mentioned, the creditor period alone is 90 days. So that's 3 months right there. But a general sort of length of time that you'll see for a probate is, roughly a year to a year and a half. Honestly, we've been closer to that year and a half on average lately. With people passing away and people working from home over the last 2 years at a higher rate than usual, we've had increased volume in the probate process. So things are just slower than they were already. But be aware that it's going to take some time. And as a personal representative, communicating that effectively with the beneficiaries is helpful too. Now, I'm sure there's always going to be some beneficiaries out there who, no matter how many times somebody's explained to them that there's a process we have to follow, that this takes some time, there's always going to be those people who just want their money now. And unfortunately, there's not much you can do there. They have to wait because there's a process that has to be followed, and you can't expedite that process necessarily either. So effectively communicating how long that takes is important. But I mentioned sort of at the start of this too, a personal representative can, attempt to do this without having any help. They can attempt to, go through probate, just file the will themselves, deal with all this themselves, not hire an attorney to assist them. The court itself can't really give you a lot of advice on what you're supposed to do or when you're supposed to do it. I mean, they'll give you the deadlines. They'll try to give you as much advice as they can, but they're not allowed to represent you in this process as a personal representative. So if you do think you'll need that help, it's incredibly important to get that help as soon as possible. Ideally, you want to seek out legal counsel before you even submit that will to probate, or before that process has really begun with like notice to creditors, because attorneys who do this area of law know the proper process, know the time frames on things, know what they should be aware of, and can really make sure that that process is a lot smoother going forward. The more sort of cleanup that has to be done after the fact, that's just of course going to make things take longer and possibly overall be more expensive than it would have been had somebody sought help relatively quickly. So, I mean, you can of course file the will right away and then go seek legal counsel as well. But a lot of times, for example, when clients come in and talk to us, they come in with the will, it hasn't been filed yet. So the first thing we do is file it and, get that process rolling for them. But ideally, like I said, you want to do that as quickly as possible so that you can get access as soon as possible as well. In general, with probate, one of the things that you really need to be aware of is, in particular, in regards to the beneficiaries, is does the will have any sort of provisions in there dictating how somebody will inherit, or what types of restrictions they're going to have on their on their inheritance. And this is particularly important with things like people who maybe are on means tested programs like Medicaid or SSI, or have some other sort of special needs trust that they need to inherit in to make sure that they maintain eligibility for benefits. So knowing what the will says, or at least having someone who can help you and walk you through what has to happen with that is really important, because what you don't want to do as a personal representative is give somebody direct access to assets that they otherwise should not have. In terms of like probate processes, I should mention too that this is not not just a firm sort of, not our firm saying that this is how long things take, or what process needs to be followed. This is the overall system of probate. So it's, if you went to probate just on your own, went through a law firm, anything like that, these rules all of course apply. So you're not going to go to a different firm or have different probate process depending on which firm you're working with. They of course may have different opinions on certain strategies and things like that, but that's more of working within the process itself, not not differentiating on the actual rules of which process you have to follow. To give you an idea on probate costs that you'll hear people talk about too, this is going to vary a lot depending on attorney's fees, size of the estate, complexity, things like that. But the general number you hear, for example, would be anywhere between 3 and 5% is what it generally works out to being. So, that's the kind of expense that probate often involves. But, it's an expense that, as long as your estate is administered properly, that the rules are followed, that people inherited the way you wanted them to, it is, well worth it, I would say. Making sure that everybody receives what you wanted them to is, of the utmost importance. One thing to be aware of too with probate is that it is potentially a public process. So what I mean by that is not that it's being televised on TV and there's not like a Judge Judy type show where people's probate estates are being administered in the courtroom. But although who knows, I say that now, maybe someday there will be. But in general, by public, I mean that it is the records are available to the public. So this is how people find out about famous people's estates when they've passed away. If they didn't have a private trust, for example, if they were just using a will or they didn't have a plan at all, this is how the media finds out what their estates are worth and what assets they had and who are the beneficiaries. So knowing that it can be a public process is important, just because that helps kind of prepare you for potentially people, coming forward and making claims that you didn't know about, or, you didn't give direct notice to if they were not, an interested party, for example. So it is potentially a public process, but for the most part, I think it's, nobody knows where to look for this sort of information unless it's, somebody's really seeking it out. But that can be very important to be aware of when you have not minor beneficiaries so much, but younger adult beneficiaries, to make sure that if that would be a concern, that, public nature, that would be a concern, that if you're setting up your own estate, that you deal with those concerns in advance rather than wait until someone's passed away. In regards to, the public nature of it, like I said, it's not that something, people are really seeking out for the most part, but this is how you'll get notice, creditors coming forward, they keep an eye out on these things in addition to those that have seen the public notice. So with probate as well, I should mention that, I mentioned you're not going to be on TV in a courthouse whether it's a public record, but you're also not necessarily going to be in the physical courtroom when this is happening. Most probates are what we would refer to as informal probates. Generally, what that means is you're filing things with the court, right? You still have to submit things directly through the court system, but you're not standing in front of a judge and going through the inventory and handing over checks to the creditors in the courtroom or things like that. You're filing things with the court, but it's mostly being administered privately or at your home or in the law office, right? It's just being submitted to the court. So it can be important as a personal representative, though, to know whether the will immediately authorizes informal probate or whether, I've seen some wills drafted this way where they required a formal probate. Formal probate is where the court will say you have to come in and do things. And it is a much more formal process, right? It is not tabletop probate where someone's dealing with it on their kitchen table. And filing things electronically. So just knowing what that says is very important. And of course, the court would tell you too once that you filed it, but knowing that in advance can prepare you. So looks like I'm running low on time here and I don't see any questions, but again, if anything we talked about today raises any concerns, you will receive a form from us that will let you say whether or not you'd like us to set aside time to talk with you. Again, those are complimentary initial consultations, so you're not paying us anything to come in and talk to us initially. Our topic next week, our webinar next week, is actually on planning for cottages, like family, cottage planning, family lake house planning, whatever you want to call it, dealing with family legacy property in general, and how to effectively pass those on or plan for disputes, those sorts of things. So if that's a topic that interests you, I'd encourage you to watch next week as well, same time as today. Otherwise, I will let you enjoy the rest of your day, and I look forward to seeing you guys next week.